You're literally working there and you're suing the government to not send you emails? Like, what a great employee this person is. And when asked about oral argument to identify every possible injury they rely upon, they said nothing about informational standing at all.
Yikes.
Hundreds of host names that, quote, appeared to be linked to internal systems, which included systems with names that indicated they were admin or portals, were made accessible from the internet. Sheesh. They opened up the ports? Liberals asking for sanctions against Elon Musk and the Trump administration. You can see this was a very short filing that was submitted over the weekend, came in from Kelly B. McClanahan. She is an attorney in Washington, D.C. for National Security Counselors at nationalsecuritylaw.org. And after Elon's email went out and told the federal government to get their act in gear and let us know who is alive and working, they sent this one. All right, listen, Your Honor, we're asking for sanctions here. This is how mad we are. On February 23rd, this entity, this law firm representing Jane Doe's 1 through 7, said we served Trump's OMB with a motion for sanctions. We busted them. They're in trouble. They did something bad. What happened? Now, in the spirit of that rule, the Jane Doe's 1 through 7 will not elaborate on the content of that motion at this time. And we'll see if we can piece together what is inside. I think I have an idea. Other than to say that the allegations are new and relate primarily to OPM's presentation to the court of the Privacy Impact Assessment, the PIA, for the government-wide email system. All right, so there's this government-wide system called the GWES. Like, anybody have an acronym for that? Some genius was like, let's just call it the GWES. Like, what does that mean? Government-wide email system. Love it. Do it. Actually, that's a good decision. I'm glad they didn't spend a lot of time on that. So that worked out well. But anyways, they have this new email system, and at some point, OPM is getting sued by these people. These people say they have access to our data. OPM came back to the court. They gave a presentation to the court. In that presentation, they must have said something. Must have said something like, this is what we're doing with the data. So they say, you remember that, Judge, right? Now, in light of rapidly unfolding events over the weekend, materially misrepresented the allegedly voluntary nature of the responses to emails sent using the system, in addition with newly discovered evidence that, as we told the court back then, OPM did not purge the government email system of information of non-employees, okay? Instead, they installed filters to keep the emails about the deferred resignation program from being sent to them. Okay, giant run-on sentence there. Tons of commas and multiple statements, but I think we can piece together what's happening. So the government, the OPM, came to the court. They said, Your Honor, this is how we're handling the data. This is a data lawsuit saying Doge can't have access to these things. OPM can't have access to these things. Government came back and said, we don't actually have access to these things, or we'll delete these things, or there's some change that we're going to make so that non-executive branch employees, aka contractors, don't get emails. We know exactly what happened. Over the weekend, Elon, somebody used the GWES system, sent everybody an email. Guess what happened? Somebody who this law firm represents, one of these Jane Does, we don't know who they are because they're proceeding pseudo-anonymously because they're cowards, in my opinion. So saying that a motion for sanctions now must not be filed or presented to the court according to some rules. Like, in other words, we can't really file this right now, but we have to. Because OPM is now emailing everybody, we have no choice but to act now. And they wrote this. Simply put, here's what happened. OPM sent an email demanding that all employees reply to the email with the list of things they did last week. And today, Trump stated that if someone does not reply, Trump said, well, they're sort of semi-fired or they're fired, according to Elon. That was posted as of today. So that's what happened. The OPM went in there. They must have told the judge, we don't even have their email addresses anymore, Judge. Like, we deleted their emails. Then one of their clients, one of these nameless Jane Does, and they must be all Jane, so all female, so 7 women, great. All sue, don't even want to use their names. One of them got an email. They're like, aha, lawyer, guess what? They told you in court that they deleted an email, but they didn't. I got one. Well, here's the problem. So they probably saw in the header or something that there were filters to keep emails from being sent to certain people. And so they caught them because they told you that they did something with the data and they didn't. So now we know we shouldn't be filing a motion for sanctions, but this happened. Extraordinarily controversial from Elon to ask government bureaucrats what they've done, and arguably unlawful actions with the GWES at rapid pace, compelling federal employees to submit more information to a system, saying they said that everything would be voluntary. Plaintiffs now maintain that the specific facts of this case warrant shortening the safe harbor period so that we can move for sanctions. Accordingly, we were asked the court to set another time in which the OPM, the Trump administration, must respond to their motion and then allow us to file for sanctions anytime after February 28th, right? They want to hit them with sanctions sanctions because they're claiming they caught him at something. The undersigned communicated with OPM's counsel, but due to a potential miscommunication, he can't state their position, and OPM's counsel was unreachable for clarification by the time we had to file this motion for unrelated personal medical reasons. All right, so hopefully whatever's going on with that family or dude is good. Accordingly, he is filing this as an opposed motion, but if he receives clarification that OPM does not oppose this motion, he'll update the court. A proposed order accompanies this. Yeah, so he's going to oppose it because he doesn't want to agree with your request for sanctions, essentially. So they are furious about this, and I'm not sure what they think they've caught here because the judge has already come out and issued an order in this case, and this order came out about a week ago on the same vein, and they actually lost this, right? So they were suing about data. These are the Jane Does. This is the same lawsuit, and this is the order from the court where he's saying, you lose. You can't force them to use or not use this email system. This is an order about emails. It says, in late January 2025, the OPM began a test of a new capability. It said that they could send important communications to all civilian federal employees from a single email address. This has already been in the works. It's not new. The OPM subsequently began using this new system to send messages to most, if not all, individuals with government email addresses. The new system uses the email address called hr@opm.gov. Okay, so this has already been in motion. They didn't set this up over the weekend. It's known as the GWES. This class action challenges the process by which they implemented the new system. So the Jane Does can't sue. You can't email us. Plaintiffs are 2 federal executive branch office employees and 5 other individuals who have .gov email addresses, but are not executive branch employees. So it looks like it's 7 women, 2 employees, 2 government contractors. They say the OPM failed to comply with the government rules, which is to conduct a privacy impact assessment. You have to do some stupid study before you initiate a new collection of information, right? So Congress, like, this is how the bureaucracy embeds itself. Before you change anything, you have to do a privacy impact assessment before you email everybody in the government. Oh, and then that has to go through processes, and then it's like an environmental study. Then there's multiple disagreements. Then you have to, appeal it or something. Somebody sues about the impact panels. The whole thing's litigated. You can't change crap for years. So that's what they're doing. They say he changed a bunch of stuff and didn't do it according to the rules. And then they threw together, once they realized, oh, we have to do a PIA before we can email everybody, then they just threw together one. They're like, well, just throw a bunch of spreadsheets together. Who cares? Whatever. According to these Janes, the OPM's failure to prepare a meaningful privacy impact assessment has left vast amounts of private data at risk. Government email addresses at risk of disclosure in case the GWES is hacked. So the reason we do these studies is to make sure data is secure, no one's getting access, blah, blah. Now, the OPM, writes the judge, for its part, contends that it was not required to prepare a PIA because OPM's reading of this section does not apply to the collection of information about government employees. It's about government employees here. We're not going after members of the public. The PIA is for the public. And even if that's wrong, either because it misread that statute or because they inadvertently collected email addresses from individuals who do not work for the federal government but use a .gov or a .mil email address, whatever, they say, we don't know. But we got the PIA. So here's your little PIA study. That's all that's required. So here's our study. And now that we've done the study, we've complied with the statutory regulations. And so there's nothing you can do. You can't examine the substance and accuracy of the PIA, right? Because they're going to say, well, this PIA is crap. Well, it's ours. We have the ability to create it. We created it. The court can't have the jurisdiction to tell us to do a better job at it or to change it. So now all that is done. They've got their little report on changing this. Pending before the court is a motion for a TRO. Okay. The Jane Does sued. Stop the OPM from touching our emails. But, says the judge, the plaintiffs have failed to carry their burden of saying that, first of all, they have standing to bring this action. Like, why can they sue? And that they likely will suffer irreparable injury in the absence of emergency relief. They failed on both of those things. So part of me is thinking that Elon saw this order and is like, great, we just won. Now I can use this email system because these 7 Jane Does who were complaining about getting emails in their inbox lost. The court will accordingly deny their motion. They lose. They have no standing, and getting an email from the OPM doesn't create irreparable injury. So get out of here. Here's the background. In 2002, Congress passed the E-Government Act to streamline government use, whatever that means. They created a bunch of laws. E-Government Act, you can see here in 2003, the OMB did some other stuff. When an agency is required to prepare a PIA, the agency's CIO, the Chief Information Officer, must review the PIA and more, then issue guidance and blah, blah, blah. Lots of stuff they're supposed to do. Those are the rules. Now, here's what happened. Summarizing the factual background is challenging in this case, says the judge, because the OPM is yet to submit an administrative record, and these Jane Does cite to a series of news reports, but they haven't offered any declarations or anything else. The people suing, their evidence is crap, and the Trump administration is not giving us any clear response because the Trump Trump administration is saying, like, it's none of your business. Like, get out of here. You're not entitled to that. You don't have jurisdiction to run the executive branch. He's saying, I don't have any info. So as far as the court can concern, however, the facts are uncontested, saying there was a PIA prepared by the OPM and Greg Hogan, the new CIO, reviewed it. That happened. Nobody disagrees. So 3 days after the Trump's transition, OPM issued a statement indicating we're testing a new capability. We're going to be bombarding you folks with emails from hr@opm.gov. Went out right away. Since then, OPM has sent several messages to large swaths of the executive workforce and perhaps inadvertently to a host of others, including apparently members of the federal judiciary. Clarence Thomas is like, I don't find this very amusing. Government contractors, state employees with the .gov email address, and many others got these emails. OPM launched this effort without conducting a PIA in advance. And like, oh crap, we got to do a study? All right, let's do it. So then 2 federal employees initiated this action, saying OPM was acting in violation of the law. You can't do that. The emergency relief that they sought was an order barring OPM or any computer from using hr@opm.gov. You can't use that email. OPM responded the following day. They said, oh, you want a little PIA assessment? Well, here it is, attached, February 5th, 2025. Here's your crap study. ChatGPT, give them an impact study. Here you go. Here it is. You're getting emails from us, and you better respond or you're fired. The court held a hearing on the motion on February 6th, denied the motion as moot. They said, make him do a study. It's done. It's here. Here's your study. As the court explained, because the OPM had conducted the impact analysis, the relief that they sought was no longer meaningful. You wanted a study, they gave it to you. Here it is. There was no reason for the court to issue an order barring them from using the system because they already did what they were required to do. Like, you sued and they changed it. Nor was the court persuaded by the Jane Does or their lawyers at the hearing. Oh, blown out. In particular, the Jane Doe's lawyers argued that the PIA was inadequate. She's like, it's not good enough. These slides aren't even colorful. They didn't even put in here. The court said, well, neither your complaint nor your motion challenged the adequacy of this. So you didn't even complain about that. And by the way, the court said, I doubt that both of you federal employees who are currently working there, they're like, you're literally working there and you're suing the government to not send you emails? Like, what a great employee this person is. Incredible. You can't send me emails saying, I don't even think you can sue, given Section 208 is focused on the general public, so it doesn't even apply to you. On February 7th, then, they amended their complaint. They made 2 changes. They're like, oh crap, so our first complaint was terrible, so let's go back and do a second draft. First, they added 5 new plaintiffs, each of whom has a .gov email address, so not official government workers, but contractors. So they went out, they're like, oh crap, who else can we go find here who we can add to this thing to make our crap case better, but none of whom work in the executive branch of the United States government. Then they added another claim. They challenged the adequacy of the PIA. They're like, well, your slides are bad, so do it again. Then the same day, they expanded the group of plaintiffs and filed another TRO, bunch of babies. Then the OPM responded, Trump, opposing that motion and saying, Your Honor, this is ridiculous. We moved to dismiss the whole complaint, lack of jurisdiction. They haven't even stated a claim here. They filed a reply now saying the Jane Does have failed to offer any evidence. All they've come into court with is with their news stories and a podcast. And in support of their motion, and instead suggested incorrectly that the court should simply treat their as of yet uncontroverted allegations as true. That judge just wrecked this attorney. Wow. Podcast and your little news clippings. Great job. Says, all right, a TRO look is an extraordinary form of relief. You can't come in here with Jon Stewart clips, all right, which a court should grant under only extraordinary circumstances. Although considered on an abbreviated schedule and without the benefit of the record, the same factors here apply. We are trying to maintain the status quo. And so we begin our inquiry here with these 2 requirements. Do you even have standing to be here? Sue on this, telling us that there are various factors to consider. Here, these Jane Does are suing because they say that they had 2 injuries because they got emails. First, they're suffering an ongoing injury simply because their information is being stored in an insecure system. OPM now has their email address and can send them emails. So that email address is in an insecure system. Warrants suing over that. And second, that their information is more vulnerable to hacking because it's in a system that's vulnerable to hacking. So obviously both of these things are speculative and reject the premise. Like, why is the OPM system insecure? Where does that come from? You have any evidence of that? Why is your email in their system bad? Because they have a lot of other info. So where's your evidence of that? And if it's vulnerable to hacking in one data system, why is it more vulnerable in another government data system? Shouldn't they all be kind of all standardized across the board? Yeah, obviously. Judge says, you have failed to carry your burden with respect to establishing that you have a substantial likelihood of even standing. Like, we don't even think you can be here based on either injury, let alone those injuries that are great enough to warrant injunctive relief. So you need a certain level of injury to get into court, and you need another level of injury, imminent, irreparable injury, to get a TRO, which would be to stop immediately whatever is happening. You have not met the TRO standard, and you haven't even met the standing standard. So this is bad. So to establish standing, you must show that there was an injury, there was causation, and that this could be redressable. Here, OPM focuses on plaintiff's failure at the first step in this inquiry, that they have failed to identify an injury in fact. They haven't proven anything is even concrete or particularized. Nothing is actual or imminent. Now, it says, Judge writes, it bears emphasis, moreover, that somebody suing cannot establish standing merely by saying the government has failed to follow a required procedure. The government didn't do that thing, for example, failing to conduct a PIA, because bare procedural violations that are divorced from any concrete harm are not actual injuries in fact, right? Otherwise, and this is kind of a public policy decision that came from the Supreme Court in 2016, the idea being, if the government didn't follow a procedure, it might be wrong, but it has to be wrong such that it created a harm. And to whom was that harm created? That person may have some standing to go after the government for not following the procedure that caused the harm. But if it's just like the government didn't do a thing because they didn't, and there's no real harm to that, you don't have the right to sue, because you could imagine if you did, everybody would be suing the government for every procedural violation. So we tie it to actual injury in fact, something happened. Now, in its opposition brief, the judge tells us, OPM identified an alternative potential source of injury to the plaintiffs, which is informational injury. Educated them. Says, you could have informational injury, but even if they claim that, that standard is also not satisfied here. But those lawyers didn't even talk about that theory of standing, and when asked about oral argument to identify every possible injury they rely upon, they said nothing about informational standing at all. Yikes. All right, so the DOJ was pre-butting an argument that they weren't even making. They're like, Judge, they have no standing. They don't even have informational standing. They didn't talk about it because they don't know anything about that, but they don't have it. The judge is sitting there in the oral arguments. Is there anything else? Any other theories of standing you have for us? Anything? She's like, no, I think we got it. Judge is like, are you sure? No, yeah, that's all. Nothing further. Gosh. So then he put it in the opinion. Now, as the Supreme Court has explained, not every statutory violation results in the type of injury that supports standing. It requires concrete injury. So we got to ask ourselves that question in this case. Was there injury here? We're trying to draw an analogy with OFAC alerts and others. Says, in another case, there was an erroneous OFAC alert that went out, and that was not a concrete injury because it's not tied to common law. Like getting an alert is not an injury. The mere existence of an incorrect alert in a credit file, even a credit file alert, even if it's a violation of federal law, was also not insufficient to confer article standing when suing the government. So here, neither of the injuries that these Jane Does are asserting have identified are sufficient for standing at all. Their first injury, the mere fact that their .gov email addresses are being stored on an allegedly unsecured system, cannot survive precedent. And even assuming that their .gov email addresses are being held on unsecured systems, that injury is no more concrete than the alleged injury of those members of TransUnion, another case, who complained about the erroneous alerts. So there's really no analog in the common law that allows us to make that claim here. So what they do is they make a policy argument unmoored to Article 3. They're saying, well, forget about standing. They say, Your Honor, if standing is not available here, the only way that any court could ever stop any agency from operating an insecure system to prevent it from being hacked would be if it had already been hacked, at which point an injunction would be pointless. She's like, well, we can only make an order after it's hacked, Judge? That doesn't make any sense. But he says, but it's not the job of the federal courts to police the security of information in the executive branch, just like it's not the job of the federal courts to police the internal notations on the credit report. It's not our job. That's their job. Now, your second theory of standing, which posits that OPM computers are connected to GWES, that they could be hacking, it's not any better. Although an actual hacking incident or an imminent hack might suffice, like if you are hacked or if something is about to be hacked, come back. But it requires way more than the theory of some future harm. Theory of future injury. It must be impending, must be non-speculative. Here, at least on the record, the Jane Does have failed to carry their burden of demonstrating that the .gov email addresses are at imminent risk of exposure at all, much less that the risk is inadequate. Rather, their arguments are relying on a highly attenuated chain of possibilities, saying much of their argument is based on an earlier hack of OPM databases, which occurred a decade ago. But the past is not always prologue, particularly when it comes to Article 3. Here, what you want is prospective injunctive relief. You don't want this to happen now, but it's a future injury. You must do more than point to a decade-old failure now, you must show that the OPM computer systems are at imminent risk of a cyber attack, or that this would be mitigated if they did a new PIA. You haven't shown any of that. As evidence that a hack is supposedly imminent, plaintiffs point to a podcast on which an anonymous, quote, systems security expert discusses potential vulnerabilities. It's over at Mueller, she wrote. Oh, gosh. Although it raises questions about the process by which GWES servers were set up, it does not provide any specific information that would allow us to conclude there's an imminent risk. To the contrary, the anonymous expert mostly addresses a past vulnerability that was fixed. He explains on the podcast, Judge, listen to the whole thing, that when the GWES was set up, hundreds of host names that, quote, appeared to be linked to internal systems, which included systems with names that indicated they were admin or portals, were made accessible from the internet. Sheesh. They opened up the ports, but those host names were later redacted, no longer visible on the public domain. The fact those systems were more visible than they should have been for some period of time after it was set up does not support your assertion that something bad's going to happen now. Although the anonymous expert also stated that the servers were possibly set up in ways that were not, quote, within the standard that you would consider an internal system to be held to, he also indicated the system was protected in other ways, such as by using a web application firewall from Akami that provides some degree of protection. The evidence also provided by the podcast is therefore mixed at best. Even your podcast is crap. More is required to satisfy Article 3. More is required to demonstrate that they need an injunction. The information that they've offered here about their emails does not satisfy the burden of showing that they face a concrete and impending risk, that their government email address is going to be misappropriated. This is not to say that they couldn't establish standing later, but they haven't done so yet. This court accordingly concludes that the Jane Does lose. Their TRO fails because they have not shown they've got any standing to sue. And although this court doesn't need to reach this issue, we also conclude that this fails for a second reason. They fail to carry their burden that they're going to suffer irreparable injury. There's a high standard for this. Injury must be irrecoverable. Here, it goes without saying. The mere fact that a .gov email address is stored in an allegedly unsecure system does not, standing alone, even if they had standing, that's not an irreparable injury. Nor can the court conclude that the risk of some future harm due to a potential hack is either certain or great. So for the reasons above, these Jane Does have failed to demonstrate that there is a significant risk that their email is going to be stolen or disclosed in the next 14 days, or that there's a risk of inadequacies. And of course, Elon just emailed them, so now they're saying, see, Judge, we just got injured again. In assessing irreparable injury, the court must also conclude the nature of the potential injury. That matters because this is not a case in which they seek to protect highly sensitive personal information. They seek to protect their work email address. The court does not doubt that government employees at times have a privacy interest in their work emails, which identify their names and stuff, but in some cases, revealing that information could result in harassment or unwanted attention. Maybe they don't want attention, which is why they're filing in under pseudonym. But here, the 7 named plaintiffs have failed to offer any evidence that even if a massive hack were to occur, the disclosure of their email addresses, along with millions of others, would subject them to great personal harassment themselves, much less that it would be certain or great. So like if there's a hack, like what makes you guys so special? Who cares? Were this a case brought under FOIA, the court might conclude the agency is entitled to withhold email because it might constitute an invasion of privacy, but this is not FOIA, and the requirement for issuance of a TRO is far more demanding. So this court accordingly concludes, you have failed to carry your burden demonstrating that there's going to be any irreparable injury at all, and we're not going to stop the OPM from sending emails out. So for the foregoing reasons, your motion for a TRO is hereby denied. Signed by Judge Randolph Moss, District Judge out of the DC Court, and saying in his final footnote, at oral argument, the Jane Doe's lawyers indicated that one of the plaintiffs works for FEMA, and he argued that associating her with FEMA could invite harassment. You see how pathetic these people are? It's pathetic. They'll know that her name is Jane Chrysalot at FEMA.gov. Oh, Jane Chrysalot, saw your email. You work for FEMA? We hate you because you're terrible. Or something like that's what it is because FEMA does such a terrible job or whatever. But that argument raised by counsel without any evidentiary support is insufficient to justify a TRO because some woman is freaked out that she works for a crap agency and people are mad at FEMA because they've abandoned our citizens in many ways. She can't even stand behind it. This civil servant can't stand behind her name and her agency. That's pathetic. And in any event, the argument fails to address the more fundamental problem. They have failed to offer evidence sufficient to permit this court. Nothing's bad is going to happen in the next 14 days. So Elon sent the email, and now this lawyer, who apparently listens to horrible podcasts, Kelly B. McClanahan out in DC, sent this in saying, Your Honor, we're now filing for sanctions. They sent another email, and they should be penalized accordingly. Meanwhile, we've got guys like Tim Burchett. Mario Nafal clipped this one for us over on X. You can see Tim Burchett got asked about these cuts and these firings and these emails bells and all these massive changes, and he's on board.
What's your reaction to challenging federal employees on their accomplishments and how that's now being asked to thousands, tens of thousands of people across the country through social media?
I think it's a great idea. You do it in private business all the time. You have to have accountability. You have to show your work. You have to show what you've done. And now we're saying the federal government should do the same. And some folks are upset about it. Obviously, they're upset because they can't show what they've done because they probably haven't done much. They're mad because they have to go back to work. I've been contacted by people that are very upset that they have to go back to work because they've moved. They don't even live in the area anymore, but they thought they could work from home. And, you know, the post-COVID days are over. We need to get people back to work. We need to show what they're doing, and we need to show the efficiencies of government, which have not been done in quite some time.
And there's many people asking about other jobs, multiple jobs, looking at salaries and tax filings and wondering how people who have full-time jobs with the government are making all that money. Where's it coming from? And now they're starting to get handles on exactly what is happening. Now, President Trump was asked about Elon's email when he was sitting down with the president of France, Emmanuel Macron. And here is what President Trump had to say about these recent developments.
Do you think that Doge could benefit from more streamlined communications? There was that email telling employees to give 5 things that they've done last week. Agency heads then told people to ignore it, but Elon Musk...
about the last email that was sent where he wanted to know what you did this week. You know why he wanted that, by the way? I thought it was great because we have people that don't show up to work and nobody even knows if they work for the government. So by asking the question, tell us what you did this week, what he's doing is saying, are you actually working? And then if you don't answer, like you're sort of semi-fired or you're fired, because a lot of people are not answering because they don't even exist. They're trying to find, that's how badly various parts of our government were run by, and especially by this last group. So what they're doing is they're trying to find out who's working for the government. We're paying other people that aren't working, and where's the money going?
Yeah, have you even logged into your email? Like, are you even checking it? Are you online, bureaucrats? So Trump looking forward to getting some answers, thought it was a great idea from Elon, and so do we.